Thank you very much for the invitation. I'm really happy to be here with you online and with the students. To begin with, I need to clarify what I'm going to talk about today. What are the notion of European migration policies refers to? So European migration policies are developed under EU law that affect third country nationals. This leads to two types of clarifications. So the EU framework first. I'm going to talk about the European Union law here, not the rule of protection established within the framework of the Council of Europe. There will also be a lot to thinking about and to talk about in this legal order, but not what I'm talking about today. On the second aspect, the notion of migration, of migrants, in the context of the EU law, the term migrants should be understood to mean a national of a non-EU country. Of course, from a national point of view, a migrant is a person whose nationality is not that of a given country in relation with the national, the citizen of the same country. The foreigner, the migrant, is the non-national, the person who does not have the nationality of a given state. However, from the point of view of European law, this approach is not appropriate because of the existence of European citizenship and the existence of rights common to all European citizens, which tend to grant these European citizens rights similar to those of national citizens. So treatment here must be non-discriminatory and equal treatment must be guaranteed. At the opposite, for third country national, so European non-citizen, does not enjoy the same rights in the European Union. Their access to the territory of the EU is conditional, and it is precisely these rules of access and residence that are the subject of European migration policies. So why I'm talking about policies, why I'm not talking about one European migration policy? European action on migration is structured in terms of objectives and competencies around three major policies. To get the full picture, let's take a look at the emergence of the EU's competence in migration issues. The first forms of structured cooperation between EU member states emerged in the 90s, but outside the institutional framework of the EU. It was international agreements between member states of the communities, but outside the legal framework of the European communities. At this time, the communities has no power, no competence on this field. The first was the Schengen cooperation, aimed at facilitating the free movement of people within the signatory countries by abolishing systematic checks at internal border and introducing compensatory measures at the external border. It was based on two founding instruments, agreements, the Schengen Agreement in 1989 and a convention implementing this agreement 5 years later. This has led to the adoption of numerous common rules on visa or border control, for example. A second form of cooperation was set up in 1919, the so-called Dublin Cooperation, also a means of an international convention concluded outside the community legal framework. The aim was to establish the criteria for determining the state responsible for an asylum application in the case of an application lodged in one of the contracting parties. So determination of the state responsible for the application. Just after the Maastricht Treaty laid the first foundations for institutionalized cooperation in this area, and this time within the EU system. However, it was only to enable cooperation in these areas in the basis of international cooperation. There was no application of the communitary method, of the integrated method. Among the issues of common interest identified in the new third pillar of cooperation relating to justice and home affairs, and which could be the subject of cooperation, we found asylum policy, the rule governing the crossing of member states' external borders, and third, immigration policy. So asylum, external borders, migration policies, three areas will now become the three main European policies. But if we return to our history perspective, the reform of the Treaty of Amsterdam brought a partial communitarization of the areas previously contained in the third pillar. And from that treaty, issues relating to visa, asylum, immigration, and other policies linked to the free movement of people, of persons, were brought within the European community and developed according to the community method. In particular, this will strengthen the role of the Commission, which will give up many impulses to the development of these policies, both in terms of policy guidelines and legal proposals. And this will initiate the emergence of numerous instruments in the EU framework. The final key stage here was the Treaty of Lisbon, which will enshrine the existence of common EU policy on these fields with ambitious objectives and extensive powers, competence to achieve them. I need to precise here that the EU does not have powers over all aspects of migration, only the one transferred to the European Union. And even in this case of transfer of competencies, the Union has only shared powers with member states. So the Union does not decide for everything. These provisions relating to European migration policies are set out in Part 3 of the Treaty on the Functioning of the European Union. Just in my slide. So Part 3 of the Treaty on the Functioning of the European Union in Title 5 on Area of Freedom, Security and Justice. In the Chapter 2, the policies on border controls, asylum and migrations. And as you can see, there are 3 articles relating to 3 different policies: border control policy, the common asylum policy, and common immigration policy. These provisions specify the EU competencies in this area, increasingly important with the growing list of areas of EU competence. The objectives are ambitious. For example, the gradual introduction of an integrated management system for external borders. Also, political programs have been drawn to ensure the coherence of the Union's actions and to refine the political project. The Tampere program in 1999, the Hague program 5 years later, the Stockholm program 5 years later, so every 5 years, the European councils adopt programs to structure the cooperation to try to put a coherent approach in this field. More recently was one of the main political program which has put a major impact on the development of these policies was the new Pact on Migration and Asylum presented by the Commission in 2020. The aim here was to establish a new beginning and to put in place a sustainable European framework to manage the interdependence between member states' policies and decisions. The aim is to propose a new approach to overcome the reluctance and resistance of member states in the need to change European rules. The limit of these rules were highlighted during the migration crisis 10 years ago. And then, even if the Commission had proposed different modifications, different new approach, it doesn't work until this new pact, this new approach proposed by the Commission was successful because numerous instruments, regulation, directives, agreements, partnerships were adopted since this new pact. In particular, a set of 10 texts, often referred as the new pact in journalistic approach or even in the institution, was adopted in May 2024. And this new pact, this new set of rules will come into force, will be in application in 2 years. The implementation will be effective in 2 years. So we are now preparing the adaptation in the member state for these new rules. Well, there is then a big set of rules, a big evolution, but in this context, what plays here for the non-discrimination, for the principle of non-discrimination? Well, there is a great deal of ambivalence here in the application of the principle of non-discrimination in that context. Firstly, because by definition, these policies are based on a distinction between people on the basis of nationality, between European citizens and third country nationals, which are subject to different rules. Furthermore, the EU is increasingly developing a logic of categorization of these third country nationals. And these sets of rules leads to an increasing categorization of migrants themselves, a diversification of control, the establishment of a widely differentiated legal status, leading a significant risk of discrimination in the implementation of this rule by the competent national authorities. The European Agency for Fundamental Rights has on several occasions pointed out that country nationals entering or residing in the EU often find their rights flouted. There are a number of reasons for this: inadequate implementation of legislation, lack of knowledge of fundamental rights, or inadequate training of officials, and sometimes discrimination and xenophobia. As you can see, there's a lot at stake in the application of non-discriminations, and the results so far are very ambivalent. European law has shown itself to be timidly committed in the fight against discrimination against migrants. And moreover, it is even potentially prejudicial to this principle with regard to various provision of practice. So it would be the structure of my presentation, as you can see on the board. While the EU is generally committed to combating discrimination against individuals, it has to be said that this commitment is more timid, more measured when these individuals are third country nationals. This is my first point. In this first part, I will develop two main ideas. The first is that the principle of non-discrimination is still largely neglected in European migration policy, as I will see in point A, and there are only few thin elements of protection targeted again to protect these people against discrimination in few European instruments. So point A, the principle of non-discrimination often neglected in European policies. This principle is not completely ignored, but it's neglected in the European migration policy. It's not the main purpose here. It is evident when we have a look on primary legislations and also policy programs. On the first point, in the framework of the primary law, in the provision in primary law, we have mention of the idea of non-discrimination, but it's not the main objective. I find two occurrences here in Article 77, which provides for the objective of ensuring the absence of any control of persons, whatever their nationality, when crossing internal borders. What is envisaged here is non-discrimination in movement within the Schengen area, linked to the absence of checks at internal border. But in reality, in practice, in other rules, it is conditional. It's only if the third country national, the migrant, is legally resident in the country. Those who stay illegally in the territory does not benefit from this freedom of movement. In Article 79, this article also set out the objective of establishing fair treatment of third country national residing illegally in the member states. It is here, therefore, an attenuated form of non-discrimination, and it only refers to fair treatment and, moreover, only for legally resident migrants. The Charter of Fundamental Rights, as you have already had occasion to see in imagine other conferences, directly enshrines the principle of discrimination in Article 21. But this is no greater help in protecting migrants against discrimination based on nationality, because discrimination on grounds of nationality is viewed more restrictively than other forms, even if the main fields are identified with no limit in paragraph 1. On the specific aspect of nationality, the paragraph 2 has a more restrictive wording, since it prohibits within the scope of the treaty and without prejudice to any special provision contained therein, which makes clear that the EU law itself can and legitimately enshrine certain forms of discrimination, of differentiated treatment on ground of nationality. Then the provisions in primary law are not very protected for migrants, not very protected with regard to the principle of discrimination. In the policy program, here again, we can find the issue of non-discrimination, but which is not a major priorities in these documents. Within the temporary program, the first main program to develop European migration policies, as we see in introduction, we can find several references to fair treatment for third country national, but again, only for those legally resident in the EU. The aim here is to grant them rights comparable to those of EU citizens and to promote non-discrimination in economic, social, and cultural life, as well as putting in place measures to combat racism and xenophobia. The objective here is present, but in flexible terms and to a limited certain category of migrants. In a more recent political program, the new Pact on Migration and Asylum, non-discrimination is considered in an even more limited way, which shows that the aspect is not one of the major polity actually in the EU. In a quantitative term, there are two occurrences of the term discrimination. And in contrast, 22 times we can find the term solidarity. So it's clear that the search for solidarity between member states in the management of migration is a much higher priority than the issue of the protection of against the discrimination, the protection for discrimination against migrants. We can find two occurrences of the term when it comes to partnership with third country. One of the objective of these partnerships is to fight discrimination. They are combated, but it's quite a bad approach. And also, we can find the term when it comes to migrant children and access to non-discriminatory to education and prompt access to integration services. So it's only here in a certain context or for certain category of migrants. So the term is rarely used, but also in the overall project, we can see that it's not a priority. I put on the slide the main program of this new pact. Their main objective is to securing borders, to have an efficient procedure, an effective system of solidarity and responsibility, to embedding migration in international partnership. There is no big place for the non-discrimination principle or even human rights, which are just mentioned inside of this map. But beyond this provision, we need to take a closer look at the various instruments adopted by the institution to see to what extent these elements of protection against discrimination are envisaged. Here, on the point B, we can see that there are targeted elements of protection in the number of European instruments. We can find elements in the international action of the EU and the external action of the EU. Regarding the internal action, so the rules which apply in the member states, there are provisions here, but they vary widely depending on the content, depending on the instrument, depending on the context. Those provisions are most of the time including in the text relating to residence permits in the EU, and then as a right, including with a resident permit. When you have access to a permit, there are different rights related to this permit and this status. But the scope of the items protected vary considerably from one system to another. For example, you see the directive on the status of long-term residents. So these are a person who has been legally residents in the EU for at least 5 years and who want to stay longer in the EU. So they are largely already integrated in the South Treaty. Here, the directive enshrines an equal treatment across a fairly broad spectrum, as you can see on the Article 1. On the list here on the board, there are very different items, different aspects, many aspects here in which the non-discrimination are applied. But on other instruments, the rights are very different, or the layout is not present. In another example here, which is not on this slide, but this one, is the blue card directive. So here it's an EU instrument which is here to attract talents in the EU. The purpose here is in issuing permits of residence to highly qualified workers. And then the aim is to put in place an attractive condition for beneficiaries. For example, easier opportunities for family reunion, opportunity to work in several member states, but also here, equal treatment with national workers in different areas that I put here again on the slide, an equal treatment in the areas such as freedom of association, education, vocational training, mutual recognition diplomas, etc. On another example, on the directive, in the directive on residence permits for seasonal workers, so with a different level of education, and which is not more priority for the EU. Here, you can find a layout on equal treatment, but the area is more reduced. For example, area in trade union or access to social security. So it's more limited. The protection against discrimination is more limited. And I should add that in the instruments related to fight against irregular migration, there are no such dispositions. There are no protect against discrimination. In the external action, we can find also disposition. The EU concludes numerous agreements, partnership with several partners, and the issue of non-discrimination is often addressed, but not most of the time as a general objective of cooperation. It's more something which are put in the end of the disposition or as a consequence of another cooperation, like a way to convince the partner to obtain several rights if they are committed in the cooperation in the fight against irregular migration as a compromise. An example here is an interesting example is the very recent agreement of the Samoa Agreement signed in 2023 in Samoa between the European Union and African, Caribbean, and Pacific states. The stakes were high since almost 18 countries are involved in this agreement, which set out binding provisions between the parties. This instrument, the agreement, is binding, and the provisions on migration are numerous. 18 articles here are devoted to this subject. But the provisions on non-discrimination remain rather evasive. For example, Article 64 on integration and non-discrimination only provides for a general cooperation and general objective to get to guarantee equal treatments. So even if the instrument is binding, this specific layout is quite very vague cooperation. Then in the application, in the instrument adopted by the EU, we can find several dispositions relating to non-discrimination there, but it's not a complete protection which are granted to third country nationals. But beyond that, even the EU is not always a good protector for this right. Sometimes the EU can potentially be a source of discrimination against migrants. And it is what I will see in my second part. Here we can see discrimination in the implementation of EU law. It will be the point A. And even more worryingly, the EU itself can have discriminating disposition on this legislation. On the point A, discrimination observed in the implementation of law of EU law. An interesting example here is the implementation of temporary protection. Following Russia's military invasion in Ukraine, the EU has granted a temporary protection and used for that quite old mechanism which had been created in 2011 by a directive, but which have never been used before this specific case in Ukraine. According to the directive, this status can be granted in the event of a mass influx of displaced persons from a third country. Such situation occurred since the directive adopted in 2011 because of the many conflicts outside the EU, in the EU doorstep, in particular the mass movement of Syrians, of Afghans, and yet it was only during the war in Ukraine that this status was granted, and this shows what this choice was a political one. The Commission emphasizes the extraordinary and exceptional nature of Russia's military invasion of Ukraine and the scale of the mass influx. But the choice to activate this temporary protection here and not for the previous situation was seen as discriminatory. In addition, this status was not granted to all Ukrainians, but only to those who were resident in Ukraine at the time of the Russian invasion and to refugees which had obtained protection at that time, but not the Ukrainians who live outside Ukraine and not asylum seekers. And here again, this difference of treatment was perceived as discriminatory. Moreover, the member states have retained an option of extending the temporary protection to other category of displaced persons from Ukraine who are unable to return in their country of origin in safe and sustainable conditions. But the member states have not used this option in the same way. And finally, the states that introduced the extension, this optional temporary protection, could withdraw it at any times. Whereas for the other beneficiaries of the temporary protection, the duration is set out in a European decision and the date is common to all. So very different treatment here, which leads to a jurisprudence of the European Court of Justice in 2024. Subsequently, in the implementation of this temporary protection, the status has led to a source of discrimination in the reception practice in member states. The search of solidarity shown toward these people, which is in itself obviously a very good thing, was unfortunately not extended to other persons or the refugees in need of international protections, so to refugees of other nationalities. In view of the considerable needs and combined with sometimes to limited resources of the states, priority was often given to the beneficiaries of temporary protection to the detriment of other refugees in terms of reception condition, housing, for example. Then we can see we sometimes move from a logic of selective protection, of categorization of refugees here to de facto discrimination. The logic of categorization in European migration law leads to several forms of discrimination. Similarly, and even more structurally, the introduction of a specific protection for vulnerable people has also led to forms of discrimination. The EU law has gradually introduced varying degrees of protection. Initially, the purpose was a better protection for the most vulnerable migrants. For example, minors or victims of criminal action in migration. It has been provided for more specific, more protective rules. This approach has been criticized in itself in the field of asylum. It is particularly delicate in this case of refugees because, by definition, people in need of protection, of international protection, are vulnerable. And the risk of persecution here, because of this risk of persecution, they need protection in the states, and so they are vulnerable. In practice, however, because here again of difficulties in implementing EU law, a lack of resources on the part of member states, and worse, a lack of political will, the protection of vulnerable people has been put into place in the detriment, to the detriment of other people in need of international protection. Instead of granting better protection for vulnerable people, states are reduced the protection of non-vulnerable people. Then this categorization leads to certain form of discrimination in state practice. But more, the worse here for me, the more worryingly, is that the EU sometimes entrenches certain forms of discriminations. A full detailed study will certainly be needed here to access the extent of this phenomenon. So students, they are a good place for a good research paper here on the subject. But for me, I'm limited. I will limit myself today with one recent example relating to the new Pact on Migration and Asylum. Here again, it's in the asylum context. Under the new rules introduced as part of the legislative package adopted in May 2024, the new Pact on Migration and Asylum, there are new rules introduced for external border controls. There is a screening regulation which provides for tighter controls at external borders in an attempt to reduce the arrival of irregular migrants. In the same time, procedure regulations provides for change in asylum procedure and a new harmonized procedure and a new border procedure, so linked with the screening procedure, the control in external borders. Here, a categorization among people arriving without paper, without the good paper at the border needs to be made. And the screening regulation organized several controls and categorization of a person according to their situation. Is it for asylum seeker, a new asylum procedure at the border is put into place. This is a procedure less protective than the traditional asylum procedure, which will become compulsory in the series of cases, and different cases, and one of which is profoundly discriminatory. This is the situation. When a person in need of international protection, whose country of nationality or habitual residence has an EU-wide recognition rate for international protection of 20% or less. Which means that if the person in need of protection, with claim an international protection, has the nationality of a country which on average through the Union has a low acceptance rate for asylum application, his or her asylum application will not be processed under the normal procedure, but under this special border procedure. And the impact of this procedure is significant, as the asylum procedure at the border is a fast-track design in practice to enable rapid processing of applications that have little chance to success. A faster processes of the application, 3 months here from the date of submission for the application compared to 6 months, which can be renewed for the standard procedure, for example. As a result, asylum seeker in border procedures will have less time to prepare their case, to find evidence, to support their application, for example, proof of a fear of persecution. And there will be less time for individual examination of the application by the authorities. This is one of the major fears in the implementation of this system. It will no longer be based on really individualized treatment for application, but it will be largely conditional on a person's nationality and therefore discriminatory. This example is indicative of a drift in EU law, which appears to be increasingly discriminatory as a result of categorization. Then this is very important here to have a look in the application here of this EU migration law, policy, regulation, directive in the years to come. So, dear students, you are the future of the defense of human rights in the application of this European policy. So you must keep in mind that migrants, third country nationals also need to be protected. Thank you for your attention.